Midnight light on a dim-lit screen, clicking through stories you wouldn't believe. Cold case trails and courtroom scenes, whispers from the grave and media dreams. Truth is stranger, hearts beat faster, in the shadows of a news disaster. Scrolling deep where secrets hide, you found the stories time won't deny. Headstones and headlines, the tales collide. Justice and mystery, side by side. From backwoods crimes to breaking news lines, you shine a light where the silence lies. Oh, headstones and headlines, you dig where the truth won't die. Small town rumors and urban fear, a voice for the lost who can't speak here. Through every name, through every case, you hold the truth in a steady place. Cameras roll but justice lingers, truth unravels through careful fingers. You tell the story, speak their names in a world that's quick to look away. Headstones and headlines, the tales collide. Justice and mystery, side by side. From backwoods crimes to great night trials, you trace the echoes through every mile. Oh, headstones and headlines, you dig where the truth won't die. Some run from the dark, you walk right in with a question and a camera lens. It's not just a crime, it's the lives they led. The voice is still talking from the books unread. Headstones and headlines, the veil is thin. Truth gets louder when you begin. With every view, with every line, you bring the forgotten back alive. Oh, headstones and headlines, you dig where the truth won't die. Yeah, headstones and headlines, you tell the stories that time can't hide.
Hey everyone, happy Wednesday. Not very happy, but I figure some of you are having a happy Wednesday. It's been a rough couple of days for me, but instead of putting this off, we're just going to get it done, because putting it off is just going to make it less fresh in our memories. And there are other stories that I do want to talk about. So I did see Manny here. Thanks for being here. Sinner, thanks for being here. Angie, anyone in the bushes who hasn't said hi, thanks for being here. Hey, Sunnyside. Yeah, I'm not going to talk about it because I'm going to get upset, but yeah. So anyways, maybe at the end of the live, so I'm hoping that Silent Angel will be here, because she sent me an article that I was able to get a hold of, and I found another one just looking for updates. So we'll read those at the very end as well, where parents of those who weren't involved in these incidents are looking for answers. Like, where do we go from here? What about the kids who weren't involved, that didn't have something to do with this? Now what? And I haven't been able to read it yet because I actually just got home like 15 minutes ago. So we'll read it together. Hey, Narcos, how are you? Yeah, I actually like well, I might as well just talk about it now. So for those of you who don't know, yesterday one of my foster kittens, Periwinkle, went to get neutered. So my brother-in-law actually dropped him off for me, and my director called, well, she didn't call me, she texted me um when I was driving home from work, and said that once anesthesia, they were done administering anesthesia, Perry's heart stopped, and yeah, he didn't make it. Um, they tried everything they could, and I didn't know that, just like humans, I guess things can happen. There's always the chance that something goes wrong, but whoever thinks that? I mean, I've had probably close to 100 foster kittens, and I've never had one not make it through surgery. I've never had one not make it after they were done with surgery. So of course I Googled it, and it could have been an adverse reaction. It could have been genetic. He may have had, a congenital condition that we didn't know about. So um today after work I went and picked him up, and he's at my parents' house now. Yeah. Yes, and he said it because my car talks to me. And so my sister is fostering the mom and 3 babies that we found at my parents' house. And so when my director texted me, she said Perry, but she said she. And so my I just saw that there was a text from her, so I hit, play. So my car reads it to me, and I was like, "Wait, Perry or OJ?" Like, and she, verified. So yeah. Uh so yeah, it's not easy, and I know he wasn't mine, but they were with me for 9 weeks. So, anyways, give me 1 second. All right, sorry, I didn't wanna blow my nose, for all you to hear. Speaking of nose, oh my gosh, this is, like, completely off topic, but I saw, Julie Skolnick was live talking about her son, and she was upset, which that's not what bothered me. What bothered me is that every other second she was snuffing, like, sucking up her snot, and it's like, I just said out loud, I'm like, "Just mute and blow your nose." Like, oh my god, it's awful, awful. Clearly she didn't hear me because she kept snuffing her nose, and I was like, "Okay, I'm not listening to this anymore." Hey, Joe, thanks for being here. Yeah, it was right. So, uh, yeah, so my dad, I thought we were gonna do it when I got there, but my nephew was there, so I think my dad wanted to wait until later, to bury him, so he'll be at my parents' house for all of eternity. All right. So, moving on. Um we are here today to finish up the second lawsuit that was filed against Ursuline High School in Youngstown, Ohio. And the first lawsuit had to do with hazing and sexual assault. with the football team. And several players, I believe it was 11 or 12, and we learned last live there are 69 on the roster. Were on the roster because their season has subsequently been canceled because so many schools said, we're not going to play them. We're not getting involved in any of that. We're not associating with them. So actually that's probably a good segue into the article that Silent Angel sent to me. And that was that the OHSAA has ruled that Ursuline players who transfer schools ineligible to play football in 2025. So Silent Angel had let us know last live that a lot of these players who were involved ended up transferring to other schools where they were being allowed to play football. And that's not right. It's not okay. 1 second. My phone was updating when I went live and I couldn't get to YouTube because for those of you who have Androids, there is an update for YouTube. Just an FYI. It decided to update right before I went live. So let me just get my chat up because I can't see it because I'm on a different screen. Hey, Pookie, thanks for being here. Yeah, the way you talks the coconuts. Listening to her at all. Well, there was nothing else on. I'm like, let's see what she's talking about. And she was upset. So I'm like, I wonder why she's upset. And it had to do with her son. And I couldn't stop thinking about her snuffing her nose. Oh my God, it was so gross. Like, just blow your nose, lady. And here I am snuffing. Okay. So it says this decision was announced in a letter sent to schools by the OHSAA on Tuesday, September 16th, which was yesterday, and comes after Ursuline canceled the remainder of its football season in the wake of hazing and sexual assault allegations involving its football team. The Ohio High School Athletic Association has officially ruled that Ursuline High School students who transfer schools will not be eligible to play football in the 25-26 school year. Okay, so now that I'm reading this, though, does that means all players that transfer, not just players who were involved? That's rough. This decision was announced in a letter sent to schools by the OHSAA on Tuesday, September 16th. Oh, wait, I just read that. I'm sorry. We understand the disappointment this decision may bring to your student athletes and families, but please know this decision was not made lightly. The letter states that moving forward, if Ursuline does have a football team next year, students enrolled at Ursuline must play for that team. If Ursuline does not have football next year, students enrolled there may play for the public school in the district where they live. Interesting. Okay, so this year, well, moving forward, if Ursuline does have a football team, they must play for Ursuline. If they don't have a football team, they can play for the public school. Hey, Silent Angel, I was hoping you'd be here. Yes, all players except the one who went back to his Pennsylvania school. He also got a scholarship to WVU. Was he, I mean, I don't know if you know, but was he one that was involved in the incident? If a student transfers to another school before the 2025 football season ends, they will have to sit out for the season, but will regain eligibility after they sit out at least 5 regular season games at the new school. or if they can be approved under an exception. Okay, so that makes no sense to me, because initially it said students who transfer will not be eligible to play football in the 2025-26 school year. But then it goes on to say if they transfer to another school before the 2025 season ends, they will have to sit out for the season. Okay, never mind. But will regain eligibility after they sit out at least 5 regular season games at the new school. Right. So they can transfer and then just sit 5 games out? Or are they saying the following season? I'm kind of confused. These 5 games are combined with the current season and next season. Okay. I should have read further. If a student transfers to a new school after the 2025 season, they will be subjected to the 50% sit-out consequence in each applicable sport, but will likely qualify for full athletic eligibility for other sports aside from football in the 2025 season. If students transfer or open enroll to a school outside of the Youngstown Diocese after the season, they will be subject to the 50% sit-out consequence in each applicable sport, but will likely not qualify for full athletic eligibility under any exception. This seems very complicated. However, if a student transfers or open enrolls to another school within the Youngstown Diocese after the season, they will be subject to the 50% sit-out consequence unless they meet specific criteria for transfers within the diocese. The full letter can be read below. Wow, that's a pretty long letter. Okay, so I'm going to actually, let me make this bigger. I will read the letter. Whoa. Okay, so it reads, the Ohio High School Athletic Association thanks you for your advocacy on behalf of your student athletes during what we know is a very difficult time for your school and football program. After careful consideration, the OHSAA has determined that football student athletes enrolled at Ursuline High School will not be permitted to participate in football at any other OHSAA member school during the 2025 season. The same would hold true if any of your football athletes transferred to another school outside of the memorialized options within Bylaw 473. This decision is based on Bylaw 473, which applies to students who have already participated in a regular season football game at their school. We understand the disappointment this decision may bring to your student athletes and families, but please know this decision was not made lightly. The OHSAA reviewed the applicable bylaws, weighed the implications for competitive balance and consistency among member schools, and reached this conclusion only after thorough deliberation. Our commitment remains to uphold the integrity of interscholastic athletics, and although this outcome is not what your community hoped for, we believe it to be in the best interest of all member schools of the OHSAA, including student athletes who could potentially be displaced by your students and or who could be impacted by their participation as opponents. That is a good point, because, I hadn't thought about initially, like, if these players transfer, they may take the spot of someone who is playing right now. Nanny says, if charges are brought, would that affect his scholarship? I would think so. I don't know. That's a good question. Silent Angel says, according to the parents I've spoken to, they are saying their sons can't play this year. Some parents are getting attorneys and fighting this. It's going to be interesting, that's for sure. And as I always say, this is why we can't have nice things. Okay, so for clarity, moving forward, If a student stays enrolled at Ursuline in 2026, if Ursuline has a football team next year, they must play for Ursuline. If Ursuline does not have football, they may play for the public school in the district where they live. If a student transfers to another school, if they transfer before this season ends, 2025, they will have to sit out the rest of the season. Next year, okay, this is more specific. The article was not very well written, in my opinion. Next year, they will regain football eligibility after they have sat out at least 5 regular season football games at the new school, combination of this season and next season, or until they can be approved under an exception, whichever comes first. All right, that makes more sense. That makes more sense. If they transfer to their local public school after this season, they will be subject to the 50% sit-out consequence in each applicable sport, but will likely qualify for full athletic eligibility under the bylaw for other sports aside from football this year, or this season, 2025. If they open enroll or transfer to a school outside the Youngstown Diocese after this season, they will be subject to the 50% sit-out consequence in each applicable sport and will likely not qualify for full athletic eligibility under any exception. If they transfer to another school within the Youngstown Diocese after this season, they will be subject to the 50% sit-out consequence in each applicable sport unless they meet the specific criteria outlined within the bylaw for transfers within the diocese. We hope this guidance helps you as you advise families. Thank you again for your understanding, cooperation, and continued partnership with the OHSAA. So looking at these options, I feel like if these students, I think the best deal, I mean, based on reading these, the best deal would be to transfer before the season ends. Because then your season's already canceled and you can't play anyways. And you would only have to sit out for 5 games. Although, looking at this first thing that they wrote, there's no consequence. You just play for Ursuline next year without having to sit out 5 games. I don't know. It's a lot. So that's actually a good segue into the next article, which is, this was from yesterday as well. One second, I was just going through comments. Texas girl, my right hand throbs, but I'm good. Oh no, did you do something to your hand? I guess I missed something. All right, so this article is again from yesterday, and Ursuline parents gather to find a path forward. Actually, no, let's watch the video because I'm going to be talking a lot today reading that lawsuit. So let's just watch the video for this one.
First time since allegations of hazing and sexual assault against Ursuline football players were made public in a lawsuit. Parents of players hurt by the cancellation of the season told their side of the story. First News anchor Stan Boney was there and joins us live tonight with what was said.
25 Ursuline High School parents gathered this evening at a church in Warren to talk about how the situation with the football team has affected the lives of the students who they say were not involved in any of the hazing or sexual assault allegations. They avoided specifics of the lawsuits, choosing instead to address the collateral damage the lawsuits have caused.
Right. And I don't play football, so I don't know how many players you need to have to play football, but 41 of the 69 players went on this football trip this past summer. Of those 41, there were like, I'm going to go 12. I'll just, because I think it was 11 or 12. There were 12, which would mean there's 57 more players that were not involved in things that were going on. Why punish them? Yet at the same time, if all of the schools that you're planning to compete against cancel against you, your season's done anyways. So, it's kind of like a damned if you do, damned if you don't situation. Either way, the kids that had nothing to do with what happened are being punished. Yeah, I suppose that is what, being a team, there's no I in team.
A group of 25, most of them Ursuline High School parents, walked to the front of the room, gathering behind Chauncey Harris, an Ursuline assistant football coach and father of 2 football players who organized the gathering of the parents.
There's a lot of kids that are, hurt by this, that are impacted, that are, broken by what has happened, what has been said about them.
Harris wanted the public to know about the comments Ursuline students are hearing, even those not associated with the football team.
It's band members and people that go to the school that are getting threats, that are getting slander, that are hearing things about their lives that are not true.
Harris said,
right, because they're being associated with Ursuline. And I can see why some of them would want to transfer out of the school because they don't want to be associated with something like hazing and sexual assault. But now the OHSAA is saying, well, if you transfer, you're not eligible to play. I don't agree with it. But I don't make the rules.
All schools should start programs so that what happened to Ursuline doesn't happen to them.
And I don't mind teaching it. It should be classes put in place about what hazing is, what sexual assault is. To be there for you.
Oh.
The most emotional speech came from Bree Boudry, who has serious heart issues. All he wanted was to walk his son, a captain on the football team, down the 50-yard line on senior night.
After 3-4 hard years of working hard and to have it snatched away, it just hurt.
I do feel it was mishandled by Ursuline.
Ken Ruby thought the Ursuline administration should have said something sooner.
When the public's only getting one side of a story, what are they going to believe? The only side that they see. And when Ursuline did finally stand up and say,
that's a good point. Ursuline only did something when they didn't do anything until after the first lawsuit was filed. I agree with that. If they had said something sooner, because you can't tell me that the diocese and administration didn't know this was coming.
something, it was too little too late.
We are Ursuline. We're standing strong for Ursuline. Nobody's standing strong for us now.
Tara Patras has freshman twins, one on the football team, one in the band. Her one son's dream was to play for Dan Reardon, the Ursuline head coach, who was placed on leave.
But I know how this coaching staff is with our boys. They push them hard. Everybody wants to play for Ursuline. And I think that's I honestly think that's a lot of reason why everybody, because they don't want to play us.
Nadia Davis was
No, I don't agree with that woman. The reason they don't want to play you is because of what is happening. They don't want their name tarnished either. It's like Ursuline is now a black cloud in that region. And I mean, yeah, the coaching staff may be great, the players may be great, but they made really bad decisions.
Mother who also spoke, her son's a senior who spent his offseason rehabbing a knee injury. He was hoping for a college scholarship. Nadia Davis said that hope and dream was stolen from her child. Live in the studio, Stan Boney, WKBN 27 First News.
Interesting. Let me just see. Sometimes they put extra info in the article itself. Let's see. Yeah, it looks like what's in the article is what was in the clip.
The need
And
for a new 911
No.
center in
Stop it. I do feel bad for the dad who spoke about his senior. You know, his senior year, he's worked hard for 4 years, and this is his senior year, you know, walking him to the 50-yard line, you know, getting those scouts, possibly, and now it's gone. It's gone. All right, let me get back to chat right quick. Silent Angel says the kid doesn't even attend Ursuline. He goes to a play school. He was just showing his friend support. Oh, public school. Okay, so he goes to a public school. Remember they said their tuitions would be paid, trying to get them to stay, I guess. Sunnyside said, I'd like to see how they'd feel if it were their daughter or son who was getting attacked. Good point. Very good point. Angel says, Ohio has a scholarship called the D Choice for elementary. You get $6,000 for high school. You get for elementary, $6,000, for high school about $8,000. All families qualify unless you are making a lot of money. Wow. How much does it cost to go there? How much is tuition? Casey says, I think they should allow kids who are not involved to transfer and play. I agree. I think the decision by OHSAA was, in my opinion, it was too harsh. It was too harsh. All right, so we are going to get into the lawsuit. We have about 21 pages left. And so we're going to start. For those of you who may not have watched part 1, I would implore you to do so. It gives a lot of detail as to what happened in regards to this young girl who was a freshman. She was violently attacked. She was picked up and thrown to the ground, and then she was dragged across turf. I think they said, no, I don't remember. I think they said 30 feet. I think it was 30 feet, if I remember correctly, which caused a lot of burn to her back and turf to be embedded in her skin. The girl initially also went to report it. Nothing was done. So then her mom went with her to talk to administration. The assistant principal promised that she would not be in classes with this other boy, the boy that did it. That was a lie. She was in at least 2 classes with him following the incident. And the one thing that I've got to say about the parents involved in both lawsuits, they kept a lot of the evidence needed to prove that what happened is true. They didn't delete things or try to delete things like the football players did, or, deleting stuff off the Facebook page, things like that. They weren't trying to cover stuff up. Ed Choice. Okay, gotcha, Silent Angel. Okay, so Ursuline, I believe, is $10,000. They were going to put in a new football field, so they raised their tuition. That's ironic. Actually, I'm going to do a quick Google search. What is the tuition for Ursuline High School? Oh, there's actually an Ursuline High School in New Rochelle, New York as well. Ursuline School. Well, this is Ursuline High School, Ohio. Let me just put the state in there because apparently there's... Okay, so here's Ursuline tuition and financial aid. Of course, they probably don't say how much it is. They actually have they have a lot of scholarships too. Holy crap. There's an Ursuline College too. Go figure. All right. Oh, here. Ursuline High School, Youngstown, Ohio. So it says... No, where did it go? So this is from privateschoolreview.com. So take it for what you will. It says that yearly tuition cost is $8,250. The admissions director is Maggie Damore, which is the assistant principal. They have a $10 million endowment. And so that makes sense. 10,000, to put in a new football field, which isn't needed at the moment, sadly. Okay. So let me add this to the screen. Oh, and my banner. I forgot to put my banner on this one. All right. So we left off. We had talked about the incident itself between the young girl and the boy. And so now we're getting into the aftermath, like what happened after. Hey, Cuddle, thanks for being here. Hey, Marie. And if I missed anyone else, I do apologize. Thanks for being here. Because of defendant Player-6's violent attack and continued harassment, and because defendant's assistant principal Margaret Damore and athletic director John DeSantis failed to report the matter or act, combined with defendants Ursuline High School and assistant principal Margaret Damore's retaliatory and disparate treatment, defendant was compelled to transfer schools. Wait, why did they say defendant? She would be... Okay, anyways, I don't know. It could be a typo. It just seems like defendant would be the player who did it, not the girl who got hurt. Daughter fell into another state of depression and continued desire not to return to school because of defendants. Mother rightfully feared for her daughter's safety and well-being if she returned to Ursuline. So in August 2025, mother sold their house, in which the family lived for 28 years, and moved to another school district so daughter could leave Ursuline and transfer to another high school. Mother refused to speak to Ursuline about the transfer because defendants lied to her family so many times. Mother had the new high school arrange the transfer. Defendant Ursuline High School's preferential treatment of its football players and desire to keep misconduct silent has been ongoing for years. So another thing that we learned during my last live is that there was the young girl and a friend of hers. Her friend had asked for her phone, and so she gave her friend her phone, and her friend ended up pranking one of the teachers at Ursuline. And the girl joined in because it was just, a silly joke. The victim in this case got 5-day suspension for that incident. Her friend got 2 days. 2 days, 3 days. I think it was 2 days. Yet the football player who assaulted her got nothing. Nothing at all. The Ursuline hazing complaint, attached as Example 1 and incorporated by reference, is a prime example of defendants' preferential treatment of its football players and desire to keep silent or cover up their misconduct. But this behavior isn't isolated to the hazing matter. It has occurred over several years. In the spring of 2023, after morning weightlifting, an Ursuline student who has since graduated witnessed a fight between two Ursuline football players in the locker room. Word of the fight quickly spread throughout the school, and the students openly discussed it during the day. That afternoon, Athletic Director DeSantis was distracted and visibly upset during class. After class, the witness student asked DeSantis, "Are you good with everything that happened this morning with the fight?" DeSantis became immediately defensive and in an angry tone said, "I don't know what you're talking about." He was trying to downplay and silence the matter. The witness student said, "You know what I'm talking about," and DeSantis just glared at him and didn't answer. The witness student, now fearing retaliation if he continued to discuss the fight, walked away and kept his mouth shut. That is, until the Ursuline hazing complaint was filed. He then felt safe and justified in reporting the incident. In another instance, a former Ursuline student, while attending college, witnessed a fight between two players at the college. The former student felt the college's coach unjustly punished the non-aggressor player over the aggressor who was the better player. The former student spoke to DeSantis, with whom he became friendly with during his time at Ursuline, for insight. DeSantis responded that, quote, "It's the coach's job to win games," and that, quote, "if they don't win games, they're out of a job," end quote. DeSantis continued that, quote, "sometimes they have to make tough choices to protect the better players to win games." What? What? All defendants cared about was football. Yeah. They have to make tough choices to protect the better players. Seems to me it wouldn't be a very tough choice if you're going to protect the better players so you can win games. That doesn't seem like a very tough choice. Contrarily, it seems like it would be a pretty easy choice to make. Defendants Catholic Diocese of Youngstown and Ursuline High School failed to train, supervise, and discipline defendants Damore and DeSantis on how to handle student violence and harassment, including sexual harassment, properly report child abuse, and protect students. That is, how not to treat football and football players as more important than everything. Defendant Catholic Diocese of Youngstown and Ursuline High School failed to train, supervise, and discipline defendants Damore and DeSantis about how to properly address and investigate allegations of student violence, sexual harassment, stalking, menacing, Title IX violations, and all other misconduct described above. These institutional defendants also failed to train and supervise Damore and DeSantis on fulfilling their mandatory duties to report such misconduct and abuse to law enforcement or children's services. And despite receiving federal funding, defendant Ursuline High School had no Title IX coordinator. Interesting. No Title IX coordinator. That seems like it would be a big no-no because someone has to be responsible for any complaints that come in or any violations that are submitted. That's interesting. Defendant Catholic Diocese of Youngstown, which oversees the high school, did not ensure it did or that its administrators, like defendant Damore, designated one. Claims. Although all claims below for plaintiff daughter Chef are through Mother Chef Chef's name is omitted for simplicity's sake. Claim 1. Violation of Title IX of the Civil Rights Act, Education Amendments of 1972. Plaintiffs incorporate all previous allegations. Ursuline High School, as a recipient of federal funding, is subject to Title IX, which prohibits discrimination based on sex in educational programs and activities, as well as retaliation for engaging in protected activity complaining of discrimination. Religious schools that have federal funding are only excluded from Title IX's requirements if the application of the requirements would not be consistent with the religious tenets of such organization. These religious exemptions are commonly known to include the exclusion from sports teams based on gender identity, the ability to expel pregnant students, and to have policies denying LGBTQ+ rights. Ursuline has not requested Title IX exemption regarding the sexual harassment and assault of students on the basis that preventing these assaults would conflict with its religious tenets. Nor would it, unless it wants people to believe that Catholic teaching embraces sexual harassment and warmth toward male-on-female physical violence. The sexual harassment daughter Chef endured from football player 6 was severe, pervasive, objectively offensive, and deprived her of access to educational opportunities or benefits. Ursuline, through its administrators, including defendants Damore and DeSantis, had actual knowledge of the severe, pervasive, and objectively offensive harassment daughter suffered. Despite this knowledge, Ursuline maintained a policy and practice of responding with deliberate indifference to misconduct by football players, including Player 6. This habit included the hazing detailed in the Ursuline hazing complaint. And if you have not heard that complaint, I would definitely check out my live streams on that complaint. Some of the details are hard to hear, but I think it's important that everybody know what's happening in Youngstown, Ohio. Ursuline's deliberate indifference is further evidenced by its failure to train Damore and DeSantis on recognizing and preventing sexual harassment and violence. Under Title IX of the Education Amendments of 1972, Ursuline created, tolerated, and subjected daughter Chef to a hostile educational environment because she was treated disparately based on her gender, suffered sexual harassment, assault, and other harassment, and treated her disparately in discipline. And Ursuline lacked adequate policies, training, and procedures, and deliberately failed to take appropriate preventive or remedial measures. Because of Ursuline's discriminatory policy and practice, daughter was denied equal access to the school's educational opportunities, forced to endure a hostile environment, and ultimately forced to transfer schools to escape the harassment and retaliation. On top of all that, Ursuline Assistant Principal Defendant Damore retaliated against daughter for her protected activity. Her reports in opposition to persistent sexually motivated violence, sex discrimination, and sexual harassment by Player 6 by punishing daughter with disparate treatment, detailed above, forcing daughter to transfer from Ursuline. Let's see. Silent Angel says, does all schools have the title personal? Do you mean Title IX? I'm asking because I have made complaints last year to the principal, dean of students in the diocese about an issue with a teacher last year and never went anywhere. I believe so. Do all schools have Title IX? Okay, so according to Google, not every school has Title IX. It applies to all public and private schools, district colleges, and universities that receive federal financial assistance, with some exceptions for certain religious organizations and private undergraduate colleges regarding admissions. Title IX is a federal civil rights law prohibiting sex-based discrimination in educational programs and activities. So schools covered public and private schools. Exemptions are religious organizations controlled by religious, scratch that. educational institutions controlled by religious organizations are exempt from certain parts of Title IX to the extent that its application would conflict with their religious tenets. Okay, so that was in that. We just read that. And then private undergraduate colleges, Title IX's prohibition on discrimination in admissions does not apply to private undergraduate colleges. So it seems like it covers all public elementary, middle, high schools, as well as public colleges and universities, and most private schools if they receive federal funding. But if you have private undergraduate colleges, Title IX in discrimination does not apply. So, for example, I would say like Harvard. Yeah. Okay, so so I finished there. As a direct and proximate result of Ursuline's failures, daughter suffered and will continue to suffer economic and non-economic damages, including but not limited to pain and suffering, reputational harm, betrayal, and emotional distress. Claim 2. Civil liability for failure to reporting child abuse under Ohio Rev Code 2151.421. Plaintiffs incorporate all previous allegations. Under the relevant part of Ohio Rev Code, no person described in Division A1B of this section who is acting in an official or professional capacity and knows or has reasonable cause to suspect based on facts that would cause a reasonable person in a similar position to suspect that a child under 18 years of age has suffered or faces a threat of suffering any physical or mental wound, injury, or condition of a nature that reasonably indicates abuse or neglect of the child shall fall to immediately report that knowledge or reasonable cause to suspect to the entity or person specified in this division. All right, and I'm not going to read the rest of that. Under the relevant part of Ohio Rev Code, Division A1A of this section applies to any person who is a school teacher, school employee, school authority. Under the relevant part of Ohio Rev Code, whoever violates Division A of this section is liable for compensatory and exemplary damages to the child who would have been the subject of the report that was not made. A person who brings a civil action or proceeding pursuant to this division against a person who is alleged to have violated Division A1 of this section may use in the action or proceeding reports of the other incidents of known or suspected abuse or neglect, provided that any information in a report that would identify the child who is the subject of the report or the maker of the report, if the maker is not the defendant or an agent or employee of the defendant, has been redacted. Defendants Ursuline High School, Damore and DeSantis, acting in professional and official capacities, failed to report Player-6's attack on daughter. Defendants Damore and DeSantis were agents and employees of defendant Ursuline High School, acting on its behalf and within the scope of their office or employment. Defendant Ursuline is vicariously liable. As a direct and proximate result of these actions, daughter has suffered and will continue to suffer economic and non-economic damages for which the named defendants are liable, including but not limited to pain and suffering, reputational harm, betrayal, and emotional distress. Defendants' acts were malicious, in bad faith, performed in a wanton and reckless manner, willful, egregious, and worthy of substantial sanction to punish and deter them and others from engaging in this type of unlawful conduct. Claim 3, civil liability for criminal acts reporting child abuse under Ohio Rev Code. Plaintiffs incorporate all previous allegations. Under the relevant part of Ohio Rev Code, No person described in Division A1B of this section who is acting in an official or professional capacity and knows or has reasonable cause to suspect based on facts that would cause a reasonable person in a similar position to suspect that a child under 18 years of age has suffered or faces a threat of suffering any physical or mental wound, injury, or condition of a nature that reasonably indicates abuse or neglect of the child shall fail to immediately report that knowledge or reasonable cause to suspect to entity or person specified in this division. Okay. Under Ohio Code, anyone injured in person or property by a criminal act may recover full damages in a civil action. Violations are criminal acts, indeed misdemeanors. Defendants Ursuline High School, Damore, and DeSantis, acting in professional and official capacities, failed to report Player-6's attack on daughter. The named defendants are culpable as principal offenders, complicitors, and or conspirators for the criminal act and are civilly liable. The conduct complained of above constitutes criminal acts by defendants Damore and DeSantis individually and through personal accountability for organizational conduct, and by other defendants through vicarious and organizational criminal liability. Defendants Damore and DeSantis were agents and employees of defendant Ursuline High School, acting on its behalf and within the scope of their office or employment. Acting with the kind of culpability otherwise required for the commission of the offense, its commission was also authorized, requested, commanded, and tolerated by defendant Ursuline High School's administration, acting on behalf of the organization and within the scope of the administrator's office or employment. Defendants Damore and DeSantis were agents and employees of defendant Ursuline High School as defined in Ohio Code and acted with the kind of culpability required for the commission of the offense. At least one of the following apply. In the name of the organization or on its behalf, they engaged in conduct constituting the offense. They had the primary responsibility to discharge a duty imposed on the organization by law, namely the duty to protect the students whose safety was entrusted to them, and did not discharge that duty. As a direct and proximate result of these actions, daughter has suffered and will continue to suffer economic and non-economic damages for which the named defendants are liable, including but not limited to pain and suffering, reputational harm, betrayal, and emotional distress. Defendants' acts were malicious and bad faith, performed in a wanton and reckless manner, willful, egregious, and worthy of substantial sanction to punish and deter them and others from engaging in this type of unlawful conduct. Claim 4, Ohio common law negligence and recklessness. Plaintiffs incorporate all previous allegations. The named defendants failed to exercise the care that a reasonable, prudent person would exercise in a similar situation resulting in injury. Defendants Damore and DeSantis were agents and employees of defendant Ursuline High School, acting on its behalf and within the scope of their office or employment. Ursuline High School is vicariously liable. As a school and school officials, named defendants owed a duty of care owed to daughter who was entrusted to their care at school. They breached that duty. As a direct and proximate result of these actions, daughter has suffered and will continue to suffer economic and non-economic damages for which the named defendants are liable, including but not limited to pain and suffering, reputational harm, betrayal, and emotional distress. Defendants' acts were in conscious disregard for daughter's rights, malicious, in bad faith, performed in a wanton and reckless manner, willful, egregious, and worthy of substantial sanction to punish and deter them and others from engaging in this type of unlawful conduct. Claim 5, Ohio common law, negligent supervision and reckless supervision. Plaintiffs incorporate all previous allegations. Defendants had a duty to provide reasonable supervision of students. The named defendants left Player-6 and daughter unsupervised, leading to her injuries. The school ignored repeated complaints of violence, bullying, stalking, predatory behavior, and harassment. The named defendants failed to meet the standard of reasonable and prudent educators in supervising the students. Defendants Damore and DeSantis were agents and employees of defendant Ursuline High School, acting on its behalf and within the scope of their office or employment. Ursuline High School is vicariously liable. As a school and school officials, they owed a duty of care owed to daughter who was entrusted to their care at school. They breached that duty. And then it goes into, again, the economic, non-economic damages and conscious disregard for daughter's rights. I'm not going to read that again. Claim 6. Negligent and reckless training, supervision, discipline, staffing, hiring, and retention under Ohio law. Plaintiffs incorporate all previous allegations. The named defendants failed to exercise due care, and acted in both a negligent and reckless manner in training, supervising, disciplining, staffing, hiring, and retaining the individual defendants, especially defendants Damore and DeSantis. The named defendants failed to train, supervise, and discipline defendants Damore and DeSantis about how to properly address and investigate allegations of violence, sexual harassment, stalking, menacing, and all the conduct described above. The named defendants also failed to discipline and hold defendants Damore and DeSantis accountable for failing to fulfill their mandatory duties to report such misconduct to law enforcement or children's services. The named defendants failed to train, supervise, and discipline defendants Damore and DeSantis about caring about such allegations more than football. Defendants Ursuline and the diocese's neglect and reckless conduct in this regard proximately caused daughter's injuries. As a result and proximate result of these actions, daughter has suffered and will continue to suffer damages to which the named defendants are liable. Defendants' acts were malicious and bad faith, performed in a wanton and reckless manner, willful, egregious, and worthy of substantial sanction to punish and deter them and others from engaging in this type of unlawful conduct. Claim 7, negligent infliction of emotional distress under Ohio law. Plaintiffs incorporate all previous allegations. Defendants had duties to and breached those duties, acting negligently and causing harm to daughter. As a result and proximate result of defendants' negligence, daughter suffered severe emotional distress and physical harm and injury. The distress was severe enough to disrupt her daily life. The harm caused by defendants' negligence and recklessness was reasonably foreseeable by defendants at all relevant times. As a direct and proximate result, daughter has suffered and will continue to suffer economic and non-economic damages. Defendants' acts were malicious, in bad faith, performed in a wanton and reckless manner, etc., etc., etc. Claim 8. Civil liability of parents for willful and malicious assaults by their children under Ohio Code. Interesting. Civil liability for willful and malicious assaults by their children. Plaintiffs incorporate all previous allegations. Under Ohio Code, in relevant part, any person is entitled to maintain an action to recover compensatory damages in a civil action in an amount not to exceed $10,000 in costs of suit in a court of competent jurisdiction from the parent of a child under the age of 18 if the child willfully and maliciously assaults the person by a means or force likely to produce great bodily harm. That's very interesting to me. So the parents of this boy are monetarily responsible for his actions. Player-6 willfully and maliciously assaulted daughter by means or force likely to produce great bodily harm. Daughter suffered or was assaulted in such a manner as to likely produce great bodily injury. The named defendant parents are liable for the actions of their named children. As a direct and proximate result of these actions, daughter has suffered and will continue to suffer economic and non-economic damages, and defendants' acts were malicious and bad faith, performed in a wanton and reckless manner, etc., etc., etc. Claim 9. Civil liability for criminal acts, felonious assault under Ohio Code. Plaintiffs incorporate all previous allegations. Under Ohio Code, no person shall knowingly cause physical harm to another. Under Ohio Code, a person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. That's a lot of words. Under the relevant part of Ohio Code, serious physical harm to person means any of the following. Any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. Any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Daughter's injuries constitute serious physical harm. Under Ohio Code, anyone injured in person or property by a criminal act may recover full damages in civil action. Violations are criminal acts, indeed felonies. Defendant Player 1 knowingly caused serious physical harm to daughter. The named defendant is culpable as a principal offender, complicit, and or conspirator for the criminal act and are civilly liable. I think they meant Defendant Player 6. As a direct and proximate result of these actions, daughter has suffered and will continue to suffer economic and non-economic damages. Defendant's acts were malicious and bad faith, etc., etc., etc. Claim 10. Civil liability for criminal acts under Ohio Code. Plaintiffs incorporate all previous allegations. Under the relevant part of Ohio Code, no person shall knowingly cause or attempt to cause physical harm to another. Under the relevant part of subsection B, no person shall recklessly cause serious physical harm to another. Okay, I'm going to skip that part because that's the same. This is the same that we read before for the last claim. Under Ohio Code, physical harm to persons means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Under Ohio Code, serious physical harm to person means any of the following. And I just read that as well. So we're going to skip that part. Daughter's injuries constitute physical harm and serious physical harm. Defendant Player 1 knowingly caused physical harm to daughter. Defendant Player 1 recklessly caused serious physical harm to daughter. The named defendant is culpable as a principal officer, complicit, and or conspirator. And then we have the economic, non-economic damages and the defendant's actions. Claim 11, civil liability for criminal acts aggravating menacing under Ohio Code. Plaintiffs incorporate all previous allegations. Under Ohio Code, no person shall knowingly cause another to believe that the offender will cause serious physical harm to the person. And then it says cleaned up. I don't know what that means. So anyone injured in person or property by a criminal act may recover full damages in a civil action. Violations are misdemeanor criminal acts. Defendant Player 6 committed aggravated menacing against daughter chef in all the ways described above. As a direct and proximate result, daughter will suffer economic, non-economic damages, etc., etc. Claim 12. Gosh, there's a lot of claims going on here. Civil liability for criminal acts menacing under Ohio Code. Plaintiffs incorporate all previous allegations. Under Ohio Code, no person shall knowingly cause another to believe that the offender will cause physical harm to the person. And it says cleaned up again. I don't know what that's referring to. I don't know what that means. Under Ohio Code, anyone injured in person or property by a criminal act may recover full damages. Violations are misdemeanor criminal acts. Defendant Player-6 committed menacing against daughter chef in all the ways described above. And then it has those two paragraphs again. Claim 13, civil liability for criminal acts, menacing by stalking. Plaintiffs incorporate all previous allegations. Under Ohio Code, no person, by engaging in a pattern of conduct, shall knowingly cause another person to believe that the offender will cause physical harm to the other person. Anyone injured in person or property by criminal act may recover full damages in a civil action. Violations where, as here, the victim is a minor or the offender has a history of violence toward the victim are criminal acts, indeed felonies. Defendant Player-6 committed menacing by stalking against daughter chef in all the ways described above. And we have those two paragraphs again. Claim 14, civil assault under Ohio law. Player-6 willfully threatened or attempted to harm or offensively touch daughter, which reasonably placed daughter in fear of such contact, coupled with Player-6 taking a definitive act to do so and having the apparent present ability to do harm or to commit the offensive touching. Player-6 intentionally created the fear of injury. Claim 15, civil battery under Ohio law. Player-6 harmfully or offensively touched daughter. Player-6 unlawfully touched daughter with the intent of inflicting injury. Okay. And prayer for relief. For the above reasons, plaintiff respectfully requests the following relief from the court. A, declare that defendants' acts and conduct constitute violations of federal and state law and the United States Constitution. B, enjoin defendants from retaliating against mother and daughter chef. C, enter judgment in mother and daughter chef's favor on all claims for relief. D, award mother and daughter chef full compensatory damages, economic and non-economic, including but not limited to pain and suffering, mental anguish, emotional distress, reputational harm, sense of betrayal, and trauma that they have suffered and are reasonably certain to suffer in the future. E, award mother and daughter chef punitive damages as appropriate for all intentional and malicious violations of federal and state law and constitutional rights. F, award prejudgment and post-judgment interest at the highest lawful rate. G, award mother and daughter chef their reasonable attorney fees, expert fees, and all other costs and expenses of the suit. H, award all other relief in law or equity to which mother and daughter chef is entitled and that the court deems equitable, just, or proper. Jury demand. Plaintiffs demand a trial by jury on all issues within this complaint. Respectfully submitted, Subodh Chandra and Martin Desmond. And that is it. That is it. I don't know how people can go through these, these court documents. I mean, I guess if you're in the legal field or law, you would understand it a little better, but like a lot of it's very repetitive, which I guess is important because each of those claims does reflect all of those effects. It is a lot of reading. My throat is a little sore. So I will follow this case. And it seems like there's going to be a lot more, maybe more lawsuits coming out. It seems, possibly that the parents of those students who are now being punished because of others' bad behavior may be coming. You know, and it's really sad. It's really sad that this school, Ursuline High School, protected these football players all because they want to win football games. I think a lot more is going to be exposed, and I wouldn't be surprised if Ursuline's lawyers did say, the diocese did say they're going to fight this. But I wouldn't be surprised if they don't try to make some type of settlement. Because we learned they did settle another case in the past with another student. You'd think they'd want this to just go away. But we shall see. We shall see. So I do plan on going live tomorrow, 4:30 Eastern. And there's a bunch of cases I want to talk about. It'll probably be just kind of, you know, different stories, not something specific, unless I see a story that I really want to look into. Sinner had sent me one earlier that I saw yesterday, but didn't have time to look at. It seems to be quite disturbing and hard to stomach. So I hope I will see you all tomorrow. To those of you sending me well wishes, thank you very much. I do appreciate it. Every day will get easier. But as is life, doesn't matter how many times you go through something like this, it never gets easier. Never gets easier. So have a great night, day, morning, wherever you may be. I do appreciate you. I'm not going to do a closing today just because. So have a great night. And until next time, I will see you on the flip side.